Good evening. Welcome everybody in this online event by Studium Generale. I hope you are all healthy and getting through the situation as good as possible. My name is Nina. I work for Studium Generale and I will be moderating today. And to start off, I wanted to walk through some practical issues. So I'll share this slide, which mentions the most important things as well. And by now, most of you are probably used to spending a lot of time in these online environments with colleagues and friends in Google Meet, Zoom, or other platforms. But for the people who aren't, we are now in the online environment that is used by the university. It is called Collaborate. And if you are experiencing any difficulties, you can reach out to my colleague Chantal or Karin in the chat. And they are also in charge of the settings of this meeting, and that is why you are now unable to use your microphone and camera, at least for now. At some point during the talk, our speaker Alberto will invite you all to split up into so-called breakout rooms. That means that Karen will put all the participants of this event into smaller virtual rooms with around 5-6 people. In this room, you are able to share your video and sound, to have a conversation about the topic or image that Alberto asked you to discuss. This is a very nice way to interact in an online environment. These breakout sessions will take about 5 or 6 minutes. And of course, if you don't feel like interacting, you don't have to, and you can just take a short break and get back later. When we get back in this plenary session, Alberto will ask you for a reaction on the breakout sessions, and at that point we will make sure that you are able to use your microphone in the plenary session, which means if you want for other people to be able to hear you, just click on the microphone button below. So for now, and during the 35-minute talk, you can only communicate through the chats. You can write down comments or questions there, and we will get back to these questions in the end, or during the talk if Alberto manages to look at the chats every once in a while. Please don't use the raise hand function during the talk, for the simple reason that this gives a very annoying sound, and that can be very distracting for the speaker. So without further ado, I will introduce our speaker of tonight. In these Let's Ask events, I ask University of Groningen experts to shed a light on a topical issue, something that was in the news that could use some context. And the question today is, when does humor go too far? Debates on humor and free speech are more relevant than ever, as shown by the recent series of dramatic events revolving around Charlie Hebdo's controversial cartoons, including most tragically the murder of school teacher Samuel Paty just a few weeks ago. But how can we define the limits of freedom of expression, and what are particular challenges posed by humor in this respect? During this session, we will discuss and compare different approaches to these issues, with particular attention to how law courts deal with humor in the context of free speech regulation. And Alberto Godioli is our expert of tonight. We actually were in contact a year ago, because in January it had been 5 years since the attack on Charlie Hebdo. And just before Corona hit the world, we did a great workshop together with illustrator Sanne Boekel. And this is proof of that event. This is Alberto and Sanne. This sums up the workshop. Where there was a workshop where people could make their own cartoon. It was really cool. Alberto is a senior lecturer in European culture and literature at the University of Groningen and program director of the Netherlands Research School for Literary Studies. And his research focuses on humor controversies, with particular regard to the legal regulations of humorous expression. So for now, I wanted to give the floor to Alberto. I'll share your slides. There we go. The floor is yours.
Perfect. That's great. I hope you can all see the slide. Many thanks, Nina, for your introduction, and to Studium Generale in general for the very kind invitation. Thanks everyone for being here too at this very late hour to discuss humor, free speech, and the limits of free speech. As Nina was mentioning, this is clearly a very topical issue, as shown most recently by the events that took place in France over the last couple of months, from the murder of school teacher Samuel Paty, who had shown the famous or infamous Muhammad cartoons during a class on freedom of expression, to the recent diplomatic tensions between France and Turkey over another Charlie Hebdo cartoon, among other things. So, of course, Charlie Hebdo is based in France, but these events have clear transnational, international implications, which we are also going to touch upon during the course of this session, which will be structured, by the way, in three parts. In part one, I would just like to give some brief coordinates on the legal regulation of free speech. So how courts set out to draw a line between lawful and unlawful expression in general. In part two, we will focus more closely on humor and how humor blurs this line between lawful and unlawful expression. And we will do so more specifically by focusing on two recent examples. Lastly, part three will be more about the link between humor, free speech, and blasphemy, which lies at the heart of the most recent Charlie Hebdo controversy. Okay, so that being said, let's start from part one, the legal regulation of free speech. A good starting point here, I think, is the European Convention on Human Rights, which is the framework under which the European Court of Human Rights operates. And in particular, freedom of expression is regulated by Article 10 of the European Convention, which is, I think, a very good example of the balancing act that is inherent to any form of legal regulation of freedom of expression within liberal democracies. Let's read Article 10 together. The first paragraph goes as follows: everyone has a right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. Crucially, this also applies to ideas that offend, shock, or disturb the state or any sector of the population. So far so good. This seems a very clear stance. But then if we move on to paragraph 2, the situation gets a bit more complicated. Paragraph 2 reads as follows: the exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society, in the interests of national security, territorial integrity, or public safety, for the prevention of disorder or crime, the protection of health or morals, and so on and so forth. So clearly, as you can see, it's a tough balancing act, the one that courts within and beyond Europe have to engage in when it comes to trying to regulate freedom of expression. The way in which this line between lawful and unlawful expression is drawn might change quite significantly, even within relatively comparable liberal democratic contexts. So, for example, in Europe, certain forms of hate speech, especially in Western Europe, certain forms of hate speech are more likely to be punished by law than they are in the United States, for example, which tends to follow a much more liberal approach to freedom of expression. And even within the European Court of Human Rights, there isn't one clear-cut way to draw this line. Although, at least when it comes to recent jurisprudence, we can say that there has been a growing trend to adopt the following criterion. That's to say, to protect offensive expression when it is considered to cause mere offense on a subjective level, while restricting it when it is deemed to objectively harm somebody's status in society, as is usually the case with incitement to hatred and, of course, incitement to discrimination or violence. This is clearly easier said than done, and this line between subjective offense and objective harm is sounds neater in theory than it is in practice, but this is in general the direction that is being taken by the Strasbourg court in this case. Things get even more complicated, of course, when it comes to humor, because humor has a way of being ambiguous, being open to different interpretations, and thereby blurring the lines between lawful and unlawful expression and between subjective offense and objective harm, for example. Okay, this is where we are reaching already part 2, really, of our session, and I would like this part since it's really the core of our meeting today, I would like this part to be a bit more interactive. This is why, as Nina was mentioning, we prepared a group activity for you, and that will work as follows. You can find some more indications here. So you will indeed be split very soon, in a minute or so, into smaller groups of 6 people, more or less. But before doing that, I would like you to click on this link in the chat, which you should all be able to see. I would like you to click there, and the link will take you to a worksheet that you will need for your group activity. I would like to know whether the link is actually working. Could you please let me know via the chat, simply by writing yes in the chat or by raising your hand if the link, okay, perfect. So you can see the file, that's great. Okay, good that you can open the file, because you're going to need this for the group activity, which will simply be a matter of, thank you, of having a discussion about these 2 cartoon controversies that are described in the worksheet. And in particular, I would like you to reflect on what you would do if you were the judge there. So how would you draw the line between lawful and unlawful expression? So that's the idea, nothing more than that, and then we will simply reconvene in the main room after 7 minutes to continue with our session. I think we are ready then to start the group activity. And of course, as Nina also was saying, if for any reason you don't feel comfortable with joining the group activity, feel free to keep your cameras and mics switched off and simply reflect on these cases individually, and then we will be back here in 7 minutes anyway. But clearly you're encouraged in engaging in the group activity as well. Is there any question before we start with the group activity? If so, just write in the chat. I will give you a few seconds. Otherwise, I think we can start. Okay, here we are. We are back into the main room. I hope somehow it worked. I'm not sure how well it worked. Of course, it's not the ideal situation. It would have been much nicer to have an actual on-site group activity. But I hope that at least you managed to start the conversation on these 2 controversial cartoons. Hopefully we'll be able to continue the conversation during the Q&A at the end of the session. For the time being, I just wanted to have a general sense of your thoughts about it. In order to do so, I will just launch a poll. But for the time being, indeed, I just wanted to have a general indication. And the thing that I would like to stress right now is that whenever we deal with ambiguous and controversial cartoons, such as these ones that you have seen in your worksheet, judges, courts have to operate on 2 separate but interrelated levels. One is what we can refer to as the hermeneutic level, and the other one is the meta-hermeneutic level. By hermeneutic level, I simply mean the interpretation of the cartoon. So this entails the courts tackling the question, what is simply the most accurate interpretation of the cartoon? Which is sometimes not an easy one to answer, as is the case with particularly compact and ambiguous cartoons, such as this one from Charlie Hebdo, for example. But then there is also a meta-hermeneutic level, which means that courts do not only have to try and identify the most accurate interpretation of the cartoon, provided that there is one, but they also need to try and map out all the possible different interpretations of the cartoon and establish what is the responsibility of the author, or to what extent can the author or the cartoonist or the publisher be held responsible for these different interpretations. In more concrete terms, let's think that we are dealing with a cartoon that, in our view, didn't originally mean to be racist or ableist, and so on and so forth, but then again allows for a racist or ableist interpretation simply because it is ambiguous then to what extent is the cartoonist responsible for these alternative interpretations that were not their original intention, but still are there and are somehow justifiable? So these are the two slightly different but interrelated sets of problems that courts have to deal with, both the hermeneutic level and the meta-hermeneutic level. And this is also what I try to do in my research. For instance, I look at how courts deal with these problems of interpretation, both on the hermeneutic and the meta-hermeneutic level. And I try to see how literary and cultural approaches to humor can help there. So how they can help rationalizing or harmonizing the court's behavior in that sense. Okay, we don't really have the time to delve into these matters any longer for the time being, but hopefully this was already a useful introduction or a useful tour into the legal side of these humor controversies. That being said, I would say we can move on to part 3, the final part of this first half of the talk. Then we will move on to the Q&A. And which means that we are going now to focus on the nexus of humor, free speech, and blasphemy that lies at the center of the most recent Charlie Hebdo controversies. First of all, here I would like to take a bit of a throwback to the origins of this controversy, which leads us all the way back to September 2005, when, as you might remember, Danish newspaper Jyllands-Posten published a series of 12 cartoons under the title The Face of Muhammad, and this led to a series of riots worldwide, particularly in Muslim-majority countries. A few months after that, in February 2006, Charlie Hebdo republished those cartoons in a special issue titled Muhammad Overwhelmed or Disgusted by the Fundamentalists. Soon after that, Muslim associations in France filed charges against Charlie Hebdo over incitement to hatred and discrimination. Eventually, the chief editor of Charlie Hebdo, Philippe Val, was acquitted of these charges because, according to the court, those cartoons explicitly only targeted Islamist fundamentalism and not Muslims at large. So to go back to the offense versus harm distinction that we had at the beginning, those cartoons, according to the court, might have been offensive on a subjective level, but they did not cause objective harm to the Muslim communities. This is the outcome of the trial, but as we know, this was only the start of a much longer and more complicated story that is still continuing today. And we are going to go back to this in a second. For the time being, I just wanted to stress that already in the immediate aftermath of the publication of the Danish cartoons, we could already see like a divide in the debate about the topic. So, of course, there was a vast consensus in terms of speaking up against any kind of violent response to these cartoons. But on the other hand, when it comes to more specific discussions on the limits of free speech, there was a divide between what we can call a liberal side and a more cautious side or stance towards this problem. The liberal side is well exemplified, I think, by the words of Fleming Rose, who at the time was the cultural editor of Jyllands-Posten, and who stated the following about the cartoons. Equal treatment is a democratic way to overcome traditional barriers of blood and soil for newcomers. To me, that means treating immigrants just as I would any other Danes. By treating a Muslim figure the same way that I would a Christian or Jewish icon, I was sending an important message. You are not strangers, you are here to stay, and we accept you as an integrated part of our life. It was an act of inclusion, not exclusion, an act of respect and recognition. So this is basically one of the possible outcomes of the liberal stance towards this topic of free speech and the limits of free speech in relation to blasphemy, etc. On the other hand, the more cautious stance is exemplified by the report written by the Venice Commission, which is an advisory body of the Council of Europe in 2010, which included, for example, the following statement, which is quite different, as you can see, from the one that we read right now. A new ethic of responsible intercultural relations in Europe and in the rest of the world is made necessary by the cultural diversity in modern societies and requires that the responsible exercise of the right to freedom of expression should endeavor to respect the religious beliefs and convictions of others. So we can see here already this kind of divide between the liberal and the cautious stance, which leads us to another possible poll question, which I'm going to type in right now in real time. This debate, which was already quite split indeed in the immediate aftermath of the Danish cartoons, of the publication of the Danish cartoons, it got more and more, let's say, polarized over the years, with either side creating more and more exaggerated or sometimes oversimplified version of the arguments of the counterpart. So, for example, those who support the more cautious side tended to be wrongly accused of siding with the terrorists, right? On the other hand, those who felt closer to the liberal side tend to be accused of Islamophobia or incitement to hatred, which is also, of course, a bit of an oversimplification. An example of this latter accusation can be found in a hotly debated book that was published in 2015, soon after the terrorist attacks at the headquarters of Charlie Hebdo, Who is Charlie by Emmanuel Todd. And you can see here a very representative phrasing of this accusation that is often leveled against Charlie Hebdo and in general against the unconditional supporters of the liberal side. Repetitive and systematic blasphemy against Muhammad, the central character in the religion of a group that is weak and discriminated against, should, whatever the law courts have to say, be treated as an incitement to religious, ethnic, or racial hatred. So it's a very strong statement that is being made here. And I would like to further discuss this statement in the Q&A that is going to start soon. For the time being, I would like to just conclude by saying that there should be, in my view, a way out from this very polarized version of the debate. And in that sense, I think it might be useful, it might be particularly useful to stress the importance of context. I am going to elaborate on this for just a minute. On the one hand, we can say that those who accuse Charlie Hebdo of being outright and systematically Islamophobic might be overlooking the context of the editorial line that is followed by Charlie Hebdo, as suggested, for instance, by the figures here. We can argue that Charlie Hebdo's handling of Islam should be put into the broader context of the magazine's stance against Islamist fundamentalism in particular, and on the other hand, religion in general, regardless of the specific creed or denomination. So in this first sense, context might help us gain a more balanced view of what Charlie Hebdo is doing here. On the other hand, though, one might also argue that Charlie Hebdo, when it comes to its treatment of Islam, is insensitive to context, more specifically to the social and political context experienced by Muslim minorities in France and elsewhere. In this sense, and from this perspective, I would like to conclude by referring to the notion of equiliberty as defined by French philosopher Etienne Balibar. Basically, according to Balibar, liberty, including freedom of expression, cannot be effectively promoted without at the same time striving for social equality. So one thing cannot really exist without the other. In more concrete terms, if we think about the situation we are dealing with here, religious extremism cannot really be contrasted simply by championing secular ideas of free speech in an automatic and self-celebratory manner, as Charlie Hebdo sometimes tends to do. More emphasis, according to Balibar, should rather be placed on targeting and denouncing the mechanisms of social exclusion and marginalization that create breeding ground for extremism, radicalization, and so on. So, in other words, by framing the situation merely as a fight between free speech and its enemies, the liberal side tends to overlook the deeper social and political factors underlying, indeed, the dynamics of extremism and radicalization, as we were saying. My final point here is that context, both the broader editorial context of Charlie Hebdo and the social political context around us is of the essence here and can help us hopefully reaching a more balanced view of things and having a more productive dialogue between the liberal side and the cautious side when it comes to humor controversies. I think I will stop here then, and I thank you very much for listening, and I look forward to our conversation in the Q&A.